Hello, everyone. Good morning. Thank you for joining the webinar today. My name is Ben Zelikovitz. I'm one of the co-founders of Get Quorum. And we're here today to talk about how to run successful annual owner meetings in the province of Alberta using electronic voting, virtual meetings, and maybe even using Get Quorum. We're thrilled to have our friend and lawyer at Field Law based in Edmonton, Aaron Burney, joining us. Aaron, we really appreciate you being here, and we look forward to hearing your insights a little bit later on.
Everybody.
By the end of the presentation, for all of you in attendance, you should have a very clear understanding of how electronic voting can be used effectively for condominiums in Alberta. Before we get started, though, I'm often asked how Get Quorum came to be. It's a story best shared over a beer, I assure you. However, the long story short is that I became involved in a dispute over a large-scale plumbing project in my condominium in my hometown of Toronto. The dispute spilled over into a proxy fight, and this resulted in directors being recalled or requisitioned. Shortly after the requisition, I was subsequently elected to the board of directors, where I spent approximately 4 years as a director on the board for my mid-size high-rise condominium community. It was during this time that I met my business partners, and we came to understand that there was no technology to help make owner meetings and AGMs better and more efficient. So I know this problem intimately well, and I'm excited to be here to share with you how electronic voting, virtual meetings can help your condominium AGMs be stress-free. Before we get started, we expect that this presentation should last approximately 25 minutes or so, plus or minus, and there will be every opportunity at the end of the presentation to ask some questions. There should be a Q&A tab at the bottom or maybe at the top of your screen, depending on your device, and we encourage you to submit a question at any point in time throughout the course of the presentation. All right, let's get to it. So here's a quick down of what we'll be discussing today. To start off with, we'll give you a brief overview of Get Quorum for those of you that are new to us and meeting me for the first time. Then we'll jump into the bulk of the presentation, where we'll cover some of the basic definitions of electronic voting and virtual meetings. From there, we'll have Aaron cover off Bill 53 and a whole bunch of legal considerations to be mindful of. Then we'll discuss some of the unique processes and challenges that Alberta condominiums face when it comes to virtual owner meetings. Follow that with a quick demo, some best practices, a couple case studies, and then we'll get into the Q&A period. I could feel the excitement, so let's get going. For those of you that are not familiar with Get Quorum, once again, thank you for joining us. We are an industry-leading provider of electronic voting and virtual meeting services. We have tailored our software and our service specifically for the province of Alberta. We've done so for a variety of other provinces and states throughout North America, but it's been specifically tailored to meet the needs in Alberta, and it has been reviewed by a certain Alberta condominium lawyer. Since 2015, we have provided our services to thousands of owner meetings and AGMs, and at the beginning of the pandemic is when we began hosting virtual owner meetings. One of the things that makes us really unique is that we are the only Zoom ISV voting platform on the market. This unique and formal partnership, which required Zoom to conduct an extensive review of Get Quorum software, allows us to do virtual meeting services, increase security, and offer a more flexible virtual meeting solution to meet the dynamic needs of the condominium election process all over North America. And we'll cover this in a little bit more detail later. We are proud members of CCI North and South, and we have hosted virtual meetings for the CCI National Annual General Meeting, as well as most recently for the Association of Condominium Managers of Ontario's virtual annual general meeting. And lastly, just before we move on, we're really proud to have been voted as the Associate of the Year by our largest group of customers. The Association of Condominium Managers of Ontario voted Get Quorum as the Associate of the Year for our work in innovating the virtual AGM space. Our services include electronic consent and meeting notice distribution. This helps you migrate owners from paper-based to electronic notice delivery and helps our clients reduce printing and mailing costs. We also do electronic advance proxy voting and an electronic advance balloting. which gives your owners the opportunity to submit proxies prior to their meetings in a simple and easy way to do. And then lastly, most importantly, what we're here to talk about mostly today is we offer hosted virtual meetings inclusive of real-time voting. And the trick to this service is that the advanced proxy voting, live in meeting voting, and the virtual meeting itself has been tied and integrated together on our software, which makes for at least what we think to be a pretty seamless experience. So enough about us. What we want to do is teach you a bunch about virtual meetings and some of the nuances that are important to note in the province of Alberta. So since the pandemic, as you might imagine, our virtual service has become increasingly popular. And with the introduction of Bill 53 to allow for virtual meetings in Alberta, a whole new way of meeting is now possible for Alberta condos. And frankly, we couldn't be more excited about it. So before we go any further, let's level set on some basic definitions before we hand over the presentation to Aaron. So it may seem obvious to you, but what exactly is a virtual meeting? And the way that we're going to define it today is a virtual meeting is one that takes place using electronic means. The critical point here, though, is that owners or members of the association can participate in the meeting as if they were there in person. There are two types of virtual meetings to consider. There's the virtual only meeting, which, as you might guess, is held exclusively online. So there is no in-person component. Everybody is comfortably at their home or their office. However, with increasing popularity and as restrictions ease, the concept of a hybrid virtual meeting is going to become more prevalent. So as a hybrid virtual meeting is held in conjunction with an in-person meeting and allows our clients, and more of our clients are going to be considering these. Hybrid meetings, though, while they are a big part of the future, they will add increased sophistication to the meetings. Consider stuff like audio-visual considerations, tracking in-person meeting attendance versus virtual meeting attendance, and otherwise. We've hosted a number of these meetings, and we've got some cool technology solutions to address these challenges that we'll cover for you later. So electronic voting, what is it? The electronic voting and virtual meetings, they're cousins. They're very closely related, but you got to understand that there's a little bit of difference between the two. So we're going to talk about primarily today two different types of electronic voting that happens with a virtual meeting. And the first is an electronic proxy. An electronic proxy is a general or a limited proxy completed by an owner that gives another individual authority to vote at the meeting. This is the most commonly used advanced electronic voting method in the province of Alberta. By comparison, in the state of Florida, they don't use proxies before the meeting, they use ballots. In Ontario, we use proxies before the meetings, but may also have the option to use the ballots. So in Alberta, most commonly used are general electronic proxies. The second type of vote that we're going to key in on a little bit is the real-time vote or the live in-meeting vote, which is a vote that is, of course, cast during a meeting directly by the owner during a specified voting period. And this is possible on any type of internet-enabled device. So you've got the advanced electronic proxy and you've got the live in-meeting vote. And that's where we're going to spend a lot of our time today. What are some benefits that you might want to consider when you are first considering electronic voting? So on the electronic voting side, it ensures that quorum is reached. Electronically submitted proxies count towards quorum, and it gives the owners and members the opportunity to participate in advance of the meeting. So no longer are your board members or your property managers knocking on doors to ensure that you've got quorum and that you've got a successful meeting. Because proxies make things easier, you're going to see more participation with a greater likelihood of reaching goals that may include 50, 60, sometimes as high as 80 or 90% thresholds in order to make amendments to declarations or other bylaw changes. You may need higher thresholds. So using advanced voting prior to the meeting gives every owner the chance to easily participate in the meeting. You can reduce your printing and mailing costs with using electronic distribution of your meeting materials. Electronic voting is safe and secure. And if you're going to host an in-person meeting, in a hybrid fashion, if you offer electronic voting beforehand, you can reduce the footprint of the meeting to only those that absolutely have to be there. So that's the electronic voting side. Specifically on the virtual meeting side, a lot of the benefits still ring true. It's easier for people to attend, so it's easily accessible. People from all over the world can join your general meetings if they're, if it's a vacation home or if they don't live there or if they're traveling, easy to join. Because it's easy to join, more people participate. You can reduce your costs because you're not renting venues, you're not getting cookies and wine or whatever else you might be serving your owners. And then some of the other things that are mind-blowing to our newer clients in Alberta is these meetings are streamlined, they are less time-consuming, and they're more efficient. What would you say if I told you the average meeting duration end-to-end is 75 minutes? So you've got streamlined meetings, quicker voting periods, and no interruptions. The opportunity to ensure that if there are owners that perhaps, how do I say this delicately, take up a disproportionate amount of time with their concerns during a meeting, a virtual meeting allows you to ensure that they can share their concerns while also not taking too much time throughout the course of the meeting to do so. So quick, efficient meetings, there's more control over your audience. And at the end of the day, you've got full transparency and all of the metrics, the voting, who arrived and when, all of this data is available to you. Okay, so we've covered off some of the basics with respect to the definitions of virtual meetings and electronic voting. I'm going to be quiet for a little while. I'm thrilled to have our guest Erin introduce herself and cover some of the legal considerations as it pertains to virtual meetings and electronic voting in Alberta. Erin, everyone's heard enough from me for now. Please take it away.
Thanks, Ben. Hi, everybody. I'm Erin Burney. I'm a condominium lawyer here at Field Law in Edmonton, Alberta. I've been practicing condominium law for probably about 9, almost 10 years now. It's my passion. I'm a condo nerd. It's kind of a joke with other condo lawyers at our office here, condo nerds. What I primarily do is what I like to describe as condominium problem solving. So I've worked with condominium boards, property managers, owners, developers, tenants even, to solve all manner of condominium related problems. And from time to time, I also assist condominium boards and corporations with governance issues, bylaw reviews, revisions, chairing and attending general meetings, special general meetings or annual general meetings, among various other things. So as Ben said, I'm going to be discussing some of the legal ramifications of Bill 53, and we'll get into that now. So, like condominiums pretty much everywhere in Canada, condominiums in Alberta are governed by various pieces of legislation, in particular the Condominium Property Act and the Condominium Property Regulation. It's important to note that because they are created by registration of condominium plan pursuant to the Condominium Property Act, condominiums are what are called creatures of statute. Now, this means that they can only undertake actions that are specifically authorized by their enabling legislation. The effect of this during COVID, it came out, was that condominiums could not actually convene virtual meetings unless the legislation specifically provided. It had been discussed among condo lawyers whether or not this was possible, and the prevailing opinion was that it was not. As a result, the Minister of Service Alberta here enacted Bill 53, the Service Alberta Statutes Virtual Meetings Amendment Act. Now, I should note, however, that this does not just impact condominiums. It also affected a host of other types of organizations, from business corporations to companies incorporated underneath the Companies Act, to cooperatives and also societies. So for you HOAs, homeowners associations out there, this particular piece of legislation also modified your constating legislation to allow virtual or electronic general meetings for your members as well. So it's not just aimed at helping condominium owners, but helping a whole variety of different organizations. So moving on, what it specifically amended under the Condominium Property Act was Section 31. This deals with the manner and the venue of meetings of the board and or the corporation. Previously, Section 31 had only allowed meetings of the board to be conducted electronically, but didn't talk about meetings of the organization or owners' meetings. So now what this section reads is that unless a corporation's bylaws expressly provide otherwise, a person who is entitled to attend a meeting by electronic or by a meeting of the corporation or a meeting of the board of directors can attend such a meeting by electronic means. That such meetings can be held entirely by electronic means, and that any person who is attending such a meeting by electronic means is also entitled to vote by electronic means. So this was a huge change that affected condominium corporations. One of the key things to note here is that there is explicit reference to the bylaws. So I want to highlight the importance of reviewing the individual corporation's bylaws, because they need to be examined to ensure that there are no express limiting or restricting terminology in there that would otherwise prevent a condo corporation from being able to convene an electronic meeting. So for example, if your bylaws specifically say that the meeting is to be held in person, that would be an express restriction. Prior to this, if your bylaws did say you could have electronic meetings, but before the Service Alberta Amendments Act came into force, it didn't matter if your bylaws said that you could have electronic meetings. The Act says you couldn't, so the bylaws can't correct something that the Act says you can't do. That's what I mean by being creature of statute. You can't do something that the Act doesn't expressly authorize you to do. But we don't have that problem anymore since Bill 53 came into force. Ben, if you want to just push it forward there. So as I said, persons who are entitled to attend condominium meetings, either general meetings, special general meetings, or annual general meetings, are also entitled to cast their votes at such a meeting electronically, or they can do so by submitting an advance proxy. Yeah, so that's a new thing, and that's pretty cool if you ask me. One of the things that I noted about this amendment, however, and that I did discuss with some other lawyers, and we all seem to agree on this, is that what this legislation now does is actually confer not just an entitlement, but a right to attend a meeting electronically and a right to cast your vote electronically. So what this means for condominium corporations and other organizations going forward is that even if in future, when COVID restrictions are over completely, and you once again begin convening physical meetings, you may still have to accommodate individuals who wish to attend electronically. So what Ben was talking about earlier about a hybrid meeting, those are probably going to become pretty common. You'll need to accommodate people who do not have necessarily the ability to attend virtually by having a physical space available. But as Ben said, this can severely shrink your footprint for the meeting by minimizing how many people actually need to be there physically. If everything is taking place electronically, and only those who cannot otherwise attend, who don't have the software, don't have the computer access, or don't have the computer savvy, can still attend physically. But if you do have a physical meeting, you'll have to, vice versa, accommodate those who want to attend electronically. And that's what I think that the revised legislation actually says. Ben, if you want to push it forward a little bit. Okay. So notwithstanding this shift towards being able to convene, attend, and vote electronically for your general meetings and your annual general meetings, corporations still have to comply with all of the formal requirements that attend a physical meeting. So number one, first and foremost, is notice of the meeting. Now, this is important. I can't underestimate this. Last year, I didn't get notice until a day before my meeting, so I almost missed it. And there were some pretty important issues that were being discussed, so I'm glad I found out. But in Alberta, there is a minimum 14-day written notice requirement. So that means that corporations have to provide written notice as well as send out all the documents that are specified under the Act, such as the past year's financials, the upcoming budget, the reserve fund report for the past year, etc., and anything else that's to be discussed at the meeting needs to be sent out at minimum of 14 days. And actually by sent out, I mean it needs to be received by the owners 14 days beforehand. So if you're sending these packages by ordinary mail, then they're deemed to be received 7 days after you send it by ordinary mail. So technically you need to send it 21 days in advance. Now, with the shift to electronic meetings and electronic notifications, I want to underscore that this is possible. You can send things electronically via an email address, but in Alberta, this is an opt-in provision. under the legislation, meaning that an owner would specifically have to agree to receive such notices electronically and provide the corporation with a specific email address at which they can send these notices and documents. Otherwise, the corporation is still required to send hard copies, and they would have to mail them to the owner's address for service, or they would have to drop them off at the unit or whatever address that the owner has provided for that purpose. So that's important to note. If you are going to send electronic notices, so number one, you need to obtain consent from the owner to do so. Number two, if you're going to attach documents, they have to be attached in such a way that they can be retained indefinitely. So for example, if you're using GeniePad and you send out links to download things, those links have to be have to exist longer than, it can't have a time limit on it. It has to be something that the owner can click on at any time to go and download those documents, not something that would expire, for example, after a couple of days or a week or 2 weeks or something like that. Those documents have to be available all the time, or attach the documents directly into the email itself so that the owner actually has the copies on their own hard drive and can look at them whenever they want and keep them, print them, do whatever they want with them. That's what retained indefinitely means. Okay, thanks, Ben. You can flip it to the next slide. Okay. So aside from the notice requirements and sending out documents and getting consent for receiving electronic notice, a lot of the other formal requirements still exist. The registration process that typically occurs at a physical general meeting, where you have a lineup of people and a table with the property manager and a list, and you would sign in physically, all of that still needs to take place, only it would be done electronically. So as people click on the link to attend the meeting, they automatically would be signed in under their name and their unit number, and that would be how registration would take place. Proxy certification, same thing. There'd be an opportunity to send in proxies in advance. And recently there were some changes to proxy requirements in Alberta as well, with passing of new regulations last year. So proxies need to be in a specific format, but they can be electronic or they can be hard copy. It doesn't matter. They do have to have a signature, but signatures can also be electronic, so that's okay. And they have to be dated. And newer proxies, of course, would also oust an older proxy, and proxies also have deadlines for use, so they expire after 6 months. Basically, they can also be specific for just this meeting. They can be for general purposes. They can be just for the purpose of attending quorum, and they can also specify how an owner wishes to vote, and another person can physically take that proxy to the meeting or can submit it electronically on your behalf. So there's a lot of different ways that this can be done, but it is something that has to be done before the start of the meeting. Next, of course, is establishing quorum, making sure that you do have sufficient numbers in attendance at the meeting itself. And in the old days, physical meetings, you would use the registration sheet and see who has signed up, and you would actually go down the list and count and make sure that you have either sufficient number of persons entitled to attend who are present in person or by proxy, or that you have sufficient numbers of unit factors represented. Now, this, of course, depends on your specific bylaws. So you need to look at your corporation's bylaws to see what your individual proxy requirement, or sorry, quorum requirements actually are, because they can vary. Some base it on number of persons, others base it on number of units, others still base it on number of unit factor. So those need to be examined. So next, as Ben was discussing, voting is huge. Voting is very crucial. And there's lots of different types of votes that take place at meetings. Some of them, the majority of them, tend to be voting by a show of hands, where the individual owners are asked to approve, for example, the agenda, to waive notice of the meeting or proof of notice of the meeting. And these votes generally take place by a show of hands, where it's just a majority of the number of people there present in person or by proxy voting in favor of something. And the chair would simply count the number of hands. Now, in this case, through Zoom or Get Quorum or whatever form you're using, there'd be an electronic way to raise your hand. And that's how those votes usually are done. For votes that can be more contentious, or for votes when somebody requires a poll vote, which can always be demanded, or where the vote is such that it has to be based on unit factor, Those votes can still be cast electronically. In the past, it would be very time consuming, done physically, where literally the property manager would have spreadsheets and would be adding up unit factors. And, typically you have a computer there to help you do the calculations, especially when you've got lots of units. And it's very time consuming. I've personally been at such meetings that have lasted 3.5 hours just because of the voting and how much time it takes to calculate the results when you have to take into account unit factor. So I'm very happy that we're able to now do this electronically, and that there are formats out there that allow us to do this and do it quickly. Just a quick reminder though, before votes are cast, it is important at the start of the meeting to make sure that whoever's chairing your meeting or calculating your votes has marked off or otherwise recorded who is not eligible to vote. With condominium corporations, owners who are in arrears for contributions or other amounts owing to the corporation are not technically allowed to vote on matters affecting the corporation. So those voters would be ineligible, and they would not be counted, whether for raising their hands or for a poll vote or some kind of resolution that requires unit factor counting. You could not count their vote. Okay, that's important to remember. Then I think we have one more slide here. Oh, maybe that's it. Yep, I think I got through everything.
You
okay.
did.
So I tried to highlight as many of the formal characteristics and formal requirements that I could think of, and just stress that everything that applies to a physical meeting still applies to an electronic meeting, and that it is capable of being done and addressed electronically if you have the right tools available to you. And with that, I'll turn it back to Ben.
Thank you, Erin. That was awesome. Super glad that we invited you to join us. I can see a number of questions have already queued up that I dare not answer. So hopefully you'll stick around for the Q&A period. But let us keep going. Another couple minutes, folks, for a quick demo, some case studies, and we'll get you on your way towards lunch. Okay, so we've covered off the basics and the legalities of virtual AGMs. Let's now look towards how you might go about picking the right solution for your condominium corporation. So there are a variety of options that are available to those that wish to host a virtual AGM. Choosing the right solution should not be that difficult. For starters, there are free and paid versions of web conferencing technology. For example, today we are using Zoom Webinar. There's WebEx, Microsoft Teams, Google Hangouts, all sorts of them. Generally speaking, all of these solutions will give you just enough to pull off a virtual owner meeting, but not enough for it to be a truly pleasant experience. A web conference only solution will leave something like meeting registration and voting to the organizers, and that is where things start to get tricky. I will say, in fairness, that for smaller condominium corporations, call it 20 units or less, that you could probably pull off a virtual owner meeting using just web conferencing software. For larger condominiums, webinar software alone is, generally speaking, wholly insufficient for your needs. So you've got webinar software. What's the kind of next step up that you might find? You may encounter law firms or even management companies that have solutions that will work. And while I cannot speak for all of these solutions, I can typically say that there isn't a whole heck of a lot of technology behind them. Rather, these processes or these offerings depend on manual processes to be executed before and during the meeting. And what that leads to is added time, added sophistication, and a lot of challenges during the meeting. So we're of the opinion that if you are going to go the route of having a virtual meeting, you should benefit from all that virtual meetings have to offer, which for the purposes of this audience is quicker, more efficient, and seamless meetings. So after the web conferencing software and maybe some law firms that have hacked together a solution, then you're going to start to find that there are vendors like Get Quorum, and that we are purpose-built and designed to address the unique challenges of the province of Alberta. So those are your three options: web conferences, using some manual processes, and then using a vendor like Get Quorum, for example. So let's take a look at what makes Alberta unique with respect to holding a virtual AGM, but we're going to look at it from a slightly different perspective than Aaron's, where Aaron is looking at it from a legal perspective. We're going to look at it from a practical, procedural, and mechanical perspective. So let's consider that. How a virtual AGM works and what needs to happen for it to be successful. So in this example, we're going to talk about a fictitious Alberta-based condominium with 115 units. Well, as we all know in Alberta, each unit may have unique unit factors associated to the unit. To make it more complicated, not only does each unit have a potentially unique number of unit factors, but if there are multiple registered owners, those owners in turn each have their own unique number of unit factors. So it's levels of sophistication there. So in order to do this by yourself, you'd better be good with math and Microsoft Excel to quickly calculate attendance by unit factor. So the fun in Alberta doesn't stop there. If the condo is using, for example, standalone web conferencing software, here are some other things that you have to consider that needs to be addressed by someone before and during the meeting. I think you'll find that even the best intentioned, technically savvy property manager may balk at the implications of being responsible for this stuff. So starting out, you've got collecting owner consent for electronic communication. So this part isn't awful, but it's not a lot of fun. It's important to pay attention to it though, because if you can get your ownership group onto electronic communication, the lifetime value of the savings there is significant and should be considered by all boards. So step number one, the electronic communications isn't awful. Where it starts to get tricky is when you start factoring in the proxies. So distributing and collecting proxies and identifying which attendees at your virtual meeting have submitted proxies before the meeting, because you can be sure that when you have your virtual meeting, that oftentimes people that have submitted a proxy will still show up virtually. The other thing that you'll find with owners is that they don't want to fill out proxies. They can't be bothered, or even if they do want to complete the proxy, oftentimes they're done incorrectly. So therefore, the managing of paper-based proxy submissions is not fun at all. And we all know that PMs and board members have way more important things to do than knocking on doors for owners to submit proxies. From the owner's perspective, in this day and age, it is totally reasonable for an owner to expect a reasonable, simple electronic method of participating in a meeting, even if it's simply submitting a proxy beforehand. And this is the starting point for the complexity. So we've talked about the consent process and the advanced proxy submission process, and where it all kind of culminates is during the voting period. So the process of tabulating proxy submissions, conducting attendance before a meeting to ensure that there is quorum, this is where the complexity is. You see that there are 35 people present at your virtual meeting. Well, how many unit factors does that represent? Are any of them present on proxy? This is where you start to see the complexity of doing things. Who are these people? Can you securely identify them? What unit or address do they come through? Have they submitted a proxy previously? Do you have quorum? We can go on and on. And this is where technology can set you free, where you otherwise may start to have a bit of a headache. And then lastly, during the actual voting period itself, executing and administering the voting period, the true test of whether a solution is good for you. Can your solution determine the appropriate weight of both live votes and proxy votes based on unit factors? Can you be certain that you're not duplicating votes? What if someone shows up and wants to revoke a proxy? What if there are multiple owners from the same units present? How do you bring it all together? And this is the true value where electronic voting and virtual AGM platforms can make your meetings simpler and easier to do. So if you did decide to do this on your own, you're left with manual, time-consuming processes that are prone to errors. By comparison, technology can help you run a meeting, administer voting in a quick and efficient manner. For our meetings, for example, our voting periods are 5 minutes long only, with nearly instantaneous result declaration. That's how we get our average meeting time down to somewhere around 75 to 85 minutes. It is my opinion that technology will make the old way of voting obsolete if it isn't already. And Alberta, by virtue of Bill 53, is on the cutting edge of doing this. So if you are curious, talk just very briefly about how Get Quorum's virtual service works. And essentially, we call it a hosted virtual AGM. And this means that we handle all of the technical work for you. We offer a stress-free, user-friendly experience. It saves your management team time, money, effort, and helps improve the success of your owner meeting. This is most impactful for, we would describe, from mid to larger size condominiums, particularly because it becomes a little bit more successful. So things that our technology offers is a quick and seamless registration process. So our software will securely identify and admit owners, and it identifies who is present at real time, who has voted, who has not. This means that there is no delay to start your meeting. You push start, registration is automatically calculated, and you're off to the races. No more individually identifying who a person may be, no asking people to change their usernames. All of that is locked in for them. Of course, audience engagement allows you to offer the perfect amount of participation from your ownership group. So Q&A groups, hand raises, live polling, gives the owners the full ability to participate throughout the course of the meeting while ensuring that the meeting is streamlined and that you stay on topic. Live administration and moderation. So we have a team of highly experienced moderators that have administered AGMs all over North America. We're gaining dozens of clients in Alberta. So we've got a good set of experience in Alberta, Florida, BC, Ontario, up and down the eastern seaboard of the United States. We've got moderators that are well-versed in the general processes and procedures that are used in AGMs. Then we've got our Zoom integration. We're super proud of this. It is totally unique in the market. I will show you how it looks. But essentially, your owners feel like they are in a normal Zoom meeting, except they're sitting on the Get Quorum platform. This allows us to offer a secure service that isn't available elsewhere. It allows us to do live in-meeting voting that immediately and instantly reconciles with your advanced proxy voting, with your unit factors. So with a couple clicks, your owners submit their votes. Get Quorum's platform behind the scenes does the magic and combines unit factors, proxy weighting. All of the complexity is simplified and handled by computer software. And there is a paper trail of data that allows us to unwind all of this in the event that there's ever a contested election or that more clarity is needed on what exactly happened throughout the course of the meeting. And then lastly, it is a secure and generally speaking, friendly user experience for the panelists and for the owners that are in attendance. So we're going to do a very brief demonstration here, and I know that we're going a little bit long. So I'm going to trim the demonstration to just the period of time where the owner is voting. So what we're looking at here is an email that an owner receives. And what they are given the opportunity to do is two things here. First of all, and this is roughly 14 days before the meeting, they can submit a proxy electronically prior to the meeting with a simple click. I'm going to skip showing you this process. Just trust me that it's a few clicks and the owner submits a legally binding, perfectly valid electronic proxy that goes to them, that is received by Get Quorum and management. But what we really want to focus on today is the Go to My Meeting portal button. And this is what the owner clicks on to jump into a Get Quorum virtual meeting. And what you can see is that the owner is sitting on Get Quorum's platform, but it actually looks like they are sitting inside of a webinar. And this is where the integration with Zoom is unique to Get Quorum's platform. So the owner will be sitting on their desktop or laptop or mobile device, and they will look and feel like they are in a Zoom meeting because they are. But Get Quorum's integration allows us to do integrated voting. So when it comes time for the actual voting period, with one click behind the scenes, the voting option on whatever voting matters are as required will pop up. So in this particular instance, this owner is being asked to vote on 3 members of a board. And you can see that my business partner has an unhealthy obsession with The Simpsons. So let's see who this voter is going to pick. It seems that I've been nominated for the board, so I think I get voted in, then maybe Lenny and Carl. Oh, Lenny and Monty. Okay, there you go. So with just that few clicks, that is the entirety of the voting period. And behind the scenes, Get Quorum's platform crunches the numbers. If maybe you were the board president and a certain portion of your ownership group had given you proxies to vote on your behalf, Get Quorum's system will have accounted for that weighting, the added unit factors, or the added units that you're voting on behalf of, and calculates everything in real time. So within a 3 to 5 minute voting period and with a 1 or 2 minute scrutinization process, Get Quorum can quickly and nearly instantaneously declare the results of your election. So I'm just going to hop back in. And then very quickly here, just to give you a quick insight for the dashboard, this is what our property managers have access to. And this dashboard here covers off how many people are present. Of the people that are present at the meeting, how many of them have voted, how many unit factors are present, and when all of the live voting has been completed, how many unit shares or unit factors have voted in for or against a given matter or on which director position. So the Get Quorum platform, just to give you a quick glimpse, ties everything together. All right, let's get back on track here. Give me 1 second. And we've almost got you folks out of here. So some best practices, if you're going to consider holding a virtual meeting, is you have to first be open-minded to adopt your previous AGM procedures to virtual. We think we've done a decent job of helping people translate it, but you got to be open-minded. Next, you've got bylaws. You've got a lawyer. Use them. Read the bylaws. Call your lawyer. Make sure you're doing things properly. Communicate with your owners. Let them know that they're going to be expecting communication, potentially electronically. Let them know that you're going to be doing a virtual meeting. Hold a dress rehearsal at least an hour before your meeting, if not a week before, if you've never done this. Understand and have a plan for Q&A. Some clients like to have Q&A done virtually. Some clients like to, all the Q&A is done virtually, but some like written only Q&A. Some like to allow owners to momentarily unmute their microphone to ask a question. How are you going to deal with voting? Are you going to use your own Excel-based kind of method? If you're smaller, that will work. Or are you going to use a vendor like Get Quorum to make sure everything is smoother and quicker? And then lastly, who is the best person internally to help with technical issues? Is it the property manager? Is it a certain board member? How are you going to deal with technical matters during the course of the meeting? Lastly, just a couple case studies here. So some of our Alberta-based clients, the Omega, 57 units, 20 of them showed up in person. They had quorum. They had a nice meeting. It was really short. Everyone's happy. The Puffin, which I believe to be a sea-based bird, which is curious that this is an Alberta-based condo, considering there's no sea anywhere near there. Anyhow, I digress. 38-unit condominium corporation, 55% participation from their ownership group. Quorum achieved. TCMA, this is a client of ours in the state of Florida. Mind-blowing, 12,000 residents, 5,300 units. They have their own school. They have their own police force. Mind-blowing. So they had never reached quorum. So using our platform, they achieved quorum, elected their directors for the first time. Generally speaking, super happy with us. And then lastly, in our backyard, the Gooderham, east side of Toronto, they had an unused superintendent suite. Things just a liability sitting on their balance sheet. Nobody has live-in supers anymore. So how can we repurpose this to become a rental suite? Well, got to get ownership to vote on it. So using Get Quorum, they achieved over 80% support of their ownership group, repurposed that super suite into a premium rental, and now they've got a revenue generating asset on their property. So that is it from presentation. We've got a number of questions that have been queued up. I'm going to ask Mark from Get Quorum to hop on here, and maybe Mark, you can throw some of the legal ones at Aaron to start.
Well, so Ben, actually, I've been addressing some of these as we go, and Mark and I kind of figured we would just kind of go through these pretty quickly here. But so the first question I got was, if the bylaws say persons entitled to vote are present in person or by proxy shall constitute quorum, can a virtual AGM be held given the use of the phrase in person in the bylaws? And I answered this yes. Specifically, Bill 53 expressly addresses this issue by deeming all persons who attend by electronic means to actually be present in person at that meeting. So this gets around any requirement or specification in your bylaws that might refer to being in person. So that is not something that I would categorize as an express provision that restricts the ability of the corporation to convene an electronic meeting, because it's dealt with specifically by the amendment. Okay. The next question I had: if the condos bylaws expressly limit AGMs to in-person, but then hold a virtual or hybrid meeting, how does this invalidate the meeting and all actions taken at that meeting? How can this be remedied without an amendment to the bylaws? And in response to this, I said, well, potentially it can, but the specific bylaws would need to be examined to provide an opinion on that. So like I just answered, if there's a reference to people being present or entitled to vote in person, and it's just referring to people being present in person, then it's dealt with by the amendment. But if there's other language in your bylaws that actually do require the meeting to be held physically, and it's not just a reference to being in person, then yeah, if you hold a virtual or a hybrid meeting, it could be invalidated. The way that you could deal with this, short of doing an amendment to the bylaws, which is probably going to be required at some point, and you should look at that, is to hold a physical meeting afterwards, or do an ordinary resolution in writing to attempt to validate all business that was transacted at the virtual hybrid meeting. And if you get sufficient support for the validation, then that would go a long way towards supporting it and maintaining all the business that was conducted at that previous virtual/hybrid meeting as being valid. So the next question was, if your bylaws note minimum 7 days notice requirement, is this okay? Unfortunately, no. This is one I see a lot. This is an actual example of a conflict with the legislation in which the legislation would prevail over the bylaws. The Act specifically requires no less than 14 days notice for all meetings of the corporation. That's regardless of whether it's a special general meeting or an annual general meeting. It's 14 days in all cases, okay? And you got to remember that 14 days it starts to count by the time the person receives the notice of the meeting. Then you count back 14 days to the date of the meeting. So you need to allow for additional time for actually sending out the notice of the meeting. If you do it by mail, allow for 7 days on top of that 14 days. If you do it by email or other electronic means, allow for 24 hours. So you add 1 day on top of the 7 days. There was another question about the 14-day notice requirement. Is this part of the amendment? I thought it needed to be 60 days notice. And actually, no, the 14-day notice has been required by the Act for some time. What this reminds me of, though, is a provision in the draft condo property regulation that was circulated back in 2018 and 2019 that actually contemplated a 60-day notice of a proposed meeting be sent out to unit owners to allow them to approve and finalize the agenda or submit agenda items of their own. Ultimately, the legislature decided that this provision was unworkable, added an administrative burden to condo corporations that they really didn't need, and it was subsequently removed from the final version of the regulations that came into effect January 1st, 2020. However, that being said, if your corporation does not have its own registered set of bylaws and is therefore governed by the statutory bylaws, which are found at the end of the regulations in Schedule 4, then you'll note that this provision, this 60-day notice requirement for agenda items, actually still exists. It's in those bylaws. So if your corporation is governed by those bylaws, then you would have to adhere to this. So that's something to be aware of. Okay, and then there were a couple of questions here, Ben, I think that were specifically directed to you. So I'll let Mark and you guys go through those.
You know what, Mark, I'll take it. I think it's okay. So Steve asked, will we have access to this presentation once it is concluded? And yes, we will certainly make this presentation available on our blog, and we may email it around to those that have attended after the fact. So you'll certainly have access to it, Steve. And we look forward to connecting with you after the meeting. Jack asks, is the paper trail of the electronic meeting available to owners after the meeting? So I will say that in most jurisdictions, certain sets of data can be available to the owners, though there's typically a requisition process. And I just so happen to have someone that may know the answer to that. Aaron?
If it is something that you can physically make available, then yes, technically you could. However, I think to the extent that you mean the physical record available, I don't think we're not allowed to actually release the results of specific unit votes. So you can release the results in terms of percentage and number of unit factors for each of the different votes that was conducted at the meeting, like, starting at the top. quorum level achieved, and then all the various votes that took place. As long as it just indicates, percentage or number of votes, that would be fine. But if you start getting into releasing unit numbers and names of unit owners who voted, then you're delving into a potential breach of privacy. And condominium corporations, again, just like other organizations in Alberta, are subject to privacy legislation. They are required to protect the personal information of their members, and this includes their names and how they voted on certain issues. So that level of detail would not be available or should not be available. But the overall results can be made available. Yes.
All right. Okay, Callie, good question here, Callie. Callie asks, how do candidates get updated during an AGM, or do they have to be predetermined prior to the meeting? So there may be bylaws and statutory requirements for people to nominate themselves prior to the meeting to be included in meeting packages. I will say that GetQuorum software is able to and is required to be able to handle nominations from the floor. So in the event that there is a last minute change in the slate of directors requiring the addition or the removal of a director, of a nominee for the board, the software is able to handle that, at least on GetQuorum side. If you're using another solution, then you'll have to ask that question or prepare for that eventuality. But that is a great question, Callie, and the software does allow for last minute additions to voting. And then Donald, very astute question. Donald asks, if an owner has contributions owing, such as late fees, can they still vote? So the way we do things is 24 hours prior to the meeting, the property manager for the Condominium Corporation sends GetQuorum a report or a summary on who is eligible and who is not. So if there are certain units that are not eligible for whatever reason, GetQuorum will disable their voting. And when they show up to join the meeting, now bear in mind, every owner that joins the meeting is doing so by clicking on a unique link that is unique to them. So when an owner that has been deemed to be NSF or in arrears, when they click on their link, we know exactly who they are. And when they go to vote, it will say ineligible to vote, and it will give them a reason. And if it has been, that reason has been provided to us, like they're in arrears, it will say that. So we do prevent those owners, as long as GetQuorum has been made aware of, we prevent them from participating in votes. Good question, Donald.
So just to follow on that, it's it is not just contributions owing in respect of the owner's unit. So what I mean by that is assessed condo fees, monthly condo fees, or a special levy that's outstanding. It's not just those amounts that can make you ineligible to vote if you haven't paid them. It's any other obligation owing to the corporation in respect of your unit or the common property. So if the corporation is attempting to make you responsible for damage to the carpet because your dog tracked in mud or something like that, and they needed to pay to have it cleaned, and they know it was you because it tracks right into your unit, then regardless of whether that's deemed a contribution under the bylaws or not, they can still prevent you from voting if it's unpaid at the time of the meeting. So it would include things like NSF fees that are chargeable if your monthly fee goes NSF, or if you balance a check or something like that. It can include management fees. It can include anything. What it says is any other obligation owing. Technically, that could also include not just financial obligations, but anything else, like if you've been told or directed by the board to do something or to not do something, and you haven't complied with that direction, and you're required to comply with reasonable directions from the board under your bylaws, then if that obligation is outstanding, you may not vote, you may still be ineligible to vote. So it's important to make sure that your fees are up to date, that there's no amounts outstanding, if you want to be able to vote at your meeting.
Very good, Aaron. I'm super glad you're here to help me out. Okay, Jim asks another very good question. Will GetQuorum require contact information for all owners? And if so, are there any privacy issues? And how will verification of ownership be done? Also, who would be responsible for keeping the owner info up to date? So we got a multi-parter here. So will GetQuorum require contact information for all owners? Generally speaking, we require, or we look for our clients to have at least half of their ownership group covered off with email addresses. So if you've got 100 owners or 100 units, pardon me, we would look for you to have at least 50% of those, or 50 units, have email addresses associated with them. And yeah, there are a ton of privacy issues that you need to be aware of when you are a condominium corporation and you are sharing your ownership data. You had better be sure that the third party, like a Get Quorum, that you are sharing with, you better be sure that they are compliant with PPADA, which we are. And if you're going to share data with a third party, you must make sure that the contract that you are signing, or the master services agreement, binds the third party, like a Get Quorum, and strictly defines what they may use data for. So for example, Get Quorum uses the ownership data for the execution of our services, full stop, period. You want to look out for not selling it for marketing or advertising, all the other stuff that has a negative connotation amongst ownership groups. But it is absolutely the responsibility of the board, of the property manager, to take good care of your data. Excellent question. Each owner is provided with a unique link. You got 100 owners you got 100 units. Each unit has 2 email addresses, so 200 email addresses. Each of the 200 email addresses receives their own unique secure link. So when the owner clicks on it, we can be relatively sure with great certainty that that email or that click is originating from a secured email that is provided to the owners. So owners are individually verified using email. And then lastly, those that are responsible for keeping the ownership data up to date, that is entirely on the condominium corporation. Get Quorum is merely a tool that is used at the discretion of the condominium corporation. We are reliant upon the data that is provided to us.
Just in following on that and capturing some of Ben's comments, it's not just in terms of keeping the owner information up to date. The responsibility is actually a two-way street. It is the corporation's responsibility to try and ensure that it has accurate, up-to-date owner information for the purpose of conducting these kinds of meetings or for undertaking any sort of voting, like a special resolution. But it's also incumbent and a statutory requirement that owners provide updates of their contact information to the corporation when that information changes. So, for example, if you've given the if you live in your unit for a period of time, but then you move out and you start renting out your unit, you are required to tell the corporation that you're renting out your unit. You have to tell them who's living in your unit, the monthly rent. You have to tell them what address they can reach you at, if not at the unit. That's information that you are required and expected to provide. It's not the corporation's responsibility to track you down. They need only serve you at the last address that they have for you, which is potentially the unit. Now, nowadays, if you've provided an email address and consent to receive electronic notifications, it's up to you to notify the corporation when that email address changes, or if you want to change the email address for whatever reason. Let's say, I don't know, you give them a work email address, but then you change, your employment changes and you get a new email address. So you have to update the corporation and remember to do that anytime there's a change to this information. So it is a two-way street. And in terms of the privacy issues, yeah, it is crucial to make sure that that any service providers that you engage that have access to sensitive information, for the purposes of discharging the obligations of the corporation, you are allowed to share certain information, but it is crucial that you ensure that that service provider, that contractor, whoever it is compliant with the appropriate legislation, whatever applies to them. In this case, it would be PIPEDA. In other cases, it might be PIPA. If it's an Alberta-based corporation or organization, that might apply. So it is crucial that that you ensure that they acknowledge their responsibilities and that they agree that they're not going to use that information for any other purpose other than the one that you're contracting them for. Okay, because if they misuse that information, they're actually considered an agent of the corporation, and potentially it's still the corporation who could be liable if there's a misuse. So.
Thank you, Aaron. A couple more questions here, just as we're getting a little tight on time. Is there an annual fee for Get Quorum? And if so, does that fee depend on the size of the condo corporation? Jim, you're absolutely right. Our starting fee is about $500 based on the size of your corporation, and it goes way up based on the number of units. A meeting is a meeting, though. It doesn't matter the sophistication of the meeting, provided it is only a single meeting. So it's not multi-year contracts. It's not an annual fee. It is a price per meeting. And it starts at about $500 and it goes up to and that's for our smaller corporations up to about, I think, 75 units. And then 75 to 150, which is, I would imagine, the mid to larger size. The price is slightly higher for that. So that should answer the question for Jim and Teresa. Hopefully you're satisfied with that. We can give you firm quotes based on the size of your corporations if you reach out to us. Donald had a similar question. Stuart asks, can a property management company license Get Quorum provided for many condominium associations they look after? Yes, frankly, you can. And we're happy to have that discussion with you as well. And then there's one more question here that we'll try and squeeze in. Susan asks, if there is more than one owner, they live in the same unit, receive their own email address to participate in the meeting, do they need their own computer access, i.e. each need access to a separate computer? I mean, that would probably be the best way of doing things. If I were two owners and we both lived in a suite and we both wanted to watch a meeting, I would watch the meeting on the biggest screen that we had, and then I would sit with my phone, and my other my other co-owner would sit with their phone. And if they're going to vote in separate ways, or one has not proxied the other, they're voting their unit factors, and the intent is for them both to vote their units, then yeah, you would just both maybe use your smartphones to vote during the course of the meeting. It's very flexible. So the option is totally at the ownership group. As long as you have access to your email address before and during the meeting, you can participate from whatever device. And hopefully that answers your question, Susan. Okay, so it's now 2 p.m. Aaron, I first of all want to thank you for being here. I never would have been able to answer half of this stuff. So thank you. You helped us a lot, helping us understand the legalities of things. And for everybody else that joined, we really appreciate your time. And if you have any more questions, I'm sure we're going to be following up with all of those in attendance. And otherwise, a contact at Get Quorum is the easiest way to find us. And yeah, thank you for joining us, everybody.